Good morning. Good morning. Good morning. Good morning. Hey. Good morning. Good morning. Good morning. Afternoon. I guess I should say afternoon. Evening, depending on where you're at. Next day. Some people might be already into Friday. Who knows? Hey, film. Good morning, SD Serve Girl. Hey, Baka. Hey, Rachel be gone. Rachel be here. What? What? Look at Rachel coming in strong today. Look at there. Now, y'all know if y'all received a gift from Rachel be gone, but Rachel be here. Hey, hey, Marilda. Good morning. Good morning. Hey, Fala. We have to be, we have her changing her name all the time. Rachel be here. Rachel be gone. Rachel, I'll be right back, depending on what her status is, right? Thank you. Thank you. Thank you. Awesome. Now, you know, if you receive one of those gifts, what you got to do, right? So we didn't hit that 2K. I caught it too. I caught it. It came in like last night, actually. I can't remember what time it was. It was probably like I want to say about 9:30 Mountain Standard Time. So I did catch it. I caught all the rest of them. Like, that's my thing, right? I could tell you it's like amazing on how fast that we are growing over here. It shows that people enjoy the channel, enjoy, you know, the way everything is set up, which is awesome, right? Guys, I can remember, it may sound like even strange, like I started off with 4 subscribers. You know who those 4 subscribers were? My 2 daughters, my best friend, and who else? My and my sometimes, you know how I do it. Sometimes we, together, and sometimes we not. In my boo thing, right? So it was us 4, and then I got on, and I forget what video I posted. I think I was trying to do the Diddy stuff, if y'all remember. That didn't work out that well. Oh, I like Rachel be busy. That works too. Hey, Jason, good morning. So, you said booth. Yeah. So hey, Shar, good morning. Yes, yes, yes. It's definitely growing. Yes. So I start off with 4. I never forget. I was out. I think I was doing something where I was delivering something, and I got my first like natural true subscriber, right? And that was number 5. Right? Hey, Jay West, good morning. Good morning. And I was like, oh my gosh, oh my gosh, oh my gosh. And I was like, okay, well, and then it just kind of started trickling in and trickling in and trickling in. And then along come Ali. Right? Don't worry, Jason. Don't worry. I got you. Don't you worry. Don't you worry. Marilda, okay, so long story short, because I done told the story. Yeah, I done told the story a couple times. But for all those that don't know, like I've been watching these trials, right, for the longest time, right? He said the only fan, yeah, I owe it. Like he came over, and I think I seen right after he came over, I think Rachel came over next when y'all when that group came. But it originally was just like me, Benny, then we had a couple other people that came in. I can remember Retired Not Bored, Poutin, um, and Pretty Brown Girl. And we sat up here and we watched like all the other little trials. And that's kind of how. But what made me start it is I was watching trials all the time, right? And I'm like, I'm tired of hitting my screen on the TV. The second thing is that I like panels, right? I want to get up there and I want to kind of like talk. So I'm like, well, let me create a platform or a place that's, safe where we can talk. Because I can always be in law and crime, right? I can always be over there at Court TV. But all I can do is chat. Jesse is not bringing me up, right? He not bringing me up to hear my opinion. He may say what I chat and the thing, but he ain't bringing me up. And I'm like, well, I could just do this myself and bring people up myself and talk to them myself and get their opinions and understand and kind of get their takes on it and have after trial discussions, and with it being, my baby, right? I can listen to what the chat wants, right? I can make I can what trials we gonna be in. If we gonna cover multiple trials and that's what we want to do, then that's what we do. And we just do it. And as long as everybody cool with it, we'll continue just to do it. When y'all say no, stay, we'll stay. So and I'm such like a people pleaser, right? So I can go with the win, so that's kind of that's what made me get started. That's what made me want to do it. I guess so I can kind of, be able to connect with some people. And I didn't have anybody. I'm in Arizona. I've been down here. COVID happened, so I didn't make any friends, and I was just stuck in the house all the time. And I was like, I want a whole bunch of friends, and look how I got them. So I got a whole bunch of friends now, right? I can go anywhere, absolutely anywhere, and I have somewhere to go. Hey y'all, I guess I better take us into the thing, right? I don't know how y'all feel about this, but I'm gonna go ahead and yeah, I'll be starting so we can have our TiVo type of stuff. But okay, in all fairness, in all fairness, I ain't gonna even hold y'all. They already got the verdict clock on. Hey, pretty brown girl. So they already got the verdict clock on. So let me let y'all listen to jury instructions, okay? And then we'll chop it up once we get to the verdict clock. Because they may only be back there for 30 minutes. And I don't want y'all to miss the verdict because we haven't seen the jury instructions. OMG. I'm like looking at the screen, setting everything up, like, oh my goodness, they already have verdict watch. I pay deal. So I'm gonna pull a poll up in regards to us. Yeah, I'm gonna put a poll up in regards to these new trials, and we'll see how everybody vote. Oh, pretty brown girl. Okay.
It's on here that I have articulated throughout the course of the trial, including the exhibits I used to refresh recollection, search warrants, things of that nature. Counsel and I have reviewed it. There is nothing on this USB other than what was used during trial. Counsel, do you agree to that?
That's correct, Your Honor.
We've also gone through all of the physical evidence, Your Honor, meaning the exhibits and the documents. There are four exhibits that have been removed. They are 1.109, 1.111, 1.110, and 1.117 because they were demonstrative only.
Okay.
I have talked to counsel about the evidence in terms of the forensic crime laboratory reports, as those could be considered continuing witness. Counsel and his client have communicated. They have determined that it is in their best interest to submit those to the jury and that they do not wish to have them extracted. They wish them to go back.
State agrees?
I don't have an objection, Judge. They're welcome to go back to the jury.
Okay.
That would include the autopsy, all the reports from the DNA analysts. That would include the reports from the tool mark expert, as well as the other experts, in this case, toxicology and so on. And counsel, is that correct?
That is correct.
And that was after talking to your client as well?
That is correct.
All right, very well, then those exhibits will go out to the jury.
Thank you, Your Honor.
The only question we had somewhat, Judge, was physical evidence. There are things like bloodstain cards, things of that nature. Counsel and I have talked about it, the totes themselves. Those things were touched by the crime laboratory and obviously are still potentially not something that they should potentially get without maybe some interaction with the court. So we're going to ask that all of the documentary and physical, like photographs, things of that nature, can go back with them. I don't have an objection or need a note for that. But if they wanted to, for example, see the knives or to see the totes or something of that nature, that they would just need to send a note to the court and ask to see them. Is that correct, counsel?
Yeah, we're in agreement on that, Your Honor.
All right. Thank you.
Thank you.
Thank you.
All right, anything else before we bring the jury in?
No, Your Honor.
Nothing from the state.
All right, let's bring our jury in. Please turn the phones off or have them on silent. I'm going to have the court reporter hand you the verdict form that we've put together in this case, just to have a look. Here's one for the state. Yes, sir. All right, everyone, please be seated. Good morning, ladies and gentlemen of the jury. And I'm required one last time to ask if you were able to abide by the court's previous instructions regarding access to media. Did we have any problems? All right, then I will now read you the law that applies in this case. Ladies and gentlemen of the jury, you are considering the case of the state of Georgia versus Nick Kassositis. And this is Bill of Indictment number 2024 R67 in the Superior Court of Liberty County, Georgia, the February term of court 2024. And the grand jury has indicted the defendant with the following offenses: Count 1, malice murder; Count 2, felony murder; Count 3, aggravated assault; Count 4, concealing the death of another; Count 5, possession of a knife during the commission of a felony; Count 6, possession of tools for the commission of a crime; Count 7, possession of tools for the commission of a crime; Count 8, possession of tools for the commission of a crime; Count 9, possession of tools for the commission of a crime; Count 10, possession of tools for the commission of a crime; Count 11, removal of body parts from scene of death; and Count 12, tampering with evidence. Now, you will recall at the beginning of this trial, in fact, in jury selection, the entire indictment was read to you. I'm not going to do that again, but I want to remind you that your oath requires that as you deliberate and go through each count, that you read the entire language that's inserted in each of those counts. So, ladies and gentlemen, the defendant has entered his plea of not guilty to this indictment, and the indictment and the plea forms the issue that you have to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I charge you that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to the case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law given in this charge to the facts as you find them to be. Your oath requires that you will decide this case based solely on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses, any exhibits admitted during the course of the trial. Evidence does not include the indictment, the plea of not guilty, and the opening or closing statements made by the attorneys or questions asked by the attorneys. Evidence may be either direct or circumstantial, or it can be both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average person. The law permits expert witnesses to give their opinions based upon their experience and training. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all other witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of the same witness that was made before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's testimony at trial. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe and what testimony you may not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. I charge you that a statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining determining voluntariness, you must also consider to what extent the defendant was informed of his rights, as discussed below. The burden of proof is upon the state to establish that the statement was voluntary. That is, it was freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. Number one, the defendant has the right to remain silent. Number two, if the defendant chooses not to remain silent, anything he says could be used as evidence against the defendant in court. Number three, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questioning. And number four, if the defendant did not have money for a lawyer, that a lawyer would have been provided for him to represent him before any questioning and to be present with him during questioning. The burden of proof is upon the state to establish that the constitutional warnings were mentioned and that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of the witness and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up those rights, then you would disregard the statement entirely and give it no consideration in reaching your verdict. Ladies and gentlemen, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparisons is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparisons in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but it simply means the intention to commit the act that is prohibited by law. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. I charge you that a jury is not authorized to find a person who was merely present at the scene of the crime at the time of its perpetration guilty of consenting in and concurring in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution in most criminal offenses. The accused is on trial for the offense of malice murder and felony murder, and under Georgia law, prosecution for these offenses may be commenced at any time. The exact date on which the murder took place is not a material element of the crime of malice murder or felony murder because there is no statute of limitation for those offenses. Prosecution for all other felony offenses included in this indictment must begin within 4 years after the offense has been committed. Prosecution for any misdemeanors included in this indictment must begin within 2 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within the required number of years after the offense was committed, it would be your duty to acquit the defendant. Now, ladies and gentlemen, the law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proven in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Liberty County, is a jurisdictional fact and must be proved by the state beyond a reasonable doubt as to each crime alleged in this indictment. Venue must be proven by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Ladies and gentlemen, I will now charge you on the offenses that are alleged in this bill of indictment. Count 1 alleges malice murder. For malice murder, the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Ladies and gentlemen, count 2, the defendant is charged with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. I will now charge you on the elements of aggravated assault. For aggravated assault, the state must prove the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is an object that is likely to cause or actually does cause death or serious bodily injury if used against another person. The presence of an offensive weapon or the appearance of such may be established by circumstantial evidence. The state is not required to admit into evidence the offensive weapon used by the defendant in order for the defendant to be found guilty of the offenses of malice murder, felony murder, or aggravated assault. I will now charge you, ladies and gentlemen, on possession of a knife during the commission of a felony. For possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing a felony, which is one of the following: a crime involving another person, concealing death of another, which is a felony, which I will define for you shortly. And I will now define for you the elements of possession of tools for the commission of a crime. For possession of tools for the commission of a crime, the state must prove the defendant possessed a tool or device commonly used to commit the crimes alleged in the indictment and intended to use the tool or other device to commit a crime. With regard to the charge of possession of a knife during the commission of a felony or possession of tools for the commission of a crime, the state must prove that the defendant possessed the knives or other devices at issue in this case. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the knife, tool, or device. Constructive possession means that all times of the alleged offense, the defendant may not have had direct physical control over those knives or devices, but that he did knowingly have both the ability and the intention to exercise control over those objects. Now, ladies and gentlemen, in count 4, the defendant is charged with concealing the death of another. I charge you that the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. In count 11 of the indictment, the defendant is charged with removal of body parts from the scene of death. And I charge you that it shall be unlawful for any person to remove from the scene of the death or dismemberment of any person or any human body part thereof. Now, with regard to count 12, where the defendant is charged with tampering with evidence, I charge you that a person commits the offense of tampering with evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person or to obstruct the prosecution or defense of any person, he knowingly destroys, alters, conceals, or disguises physical evidence or makes, devises, prepares, or plants false evidence. Now, ladies and gentlemen, after considering the testimony and evidence presented to you, together with the charge of the court, if you should find and believe beyond a reasonable doubt that the defendant in Liberty County, Georgia, did commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. And in that offense, in that event, the form of your verdict would be, we, the jury, find the defendant guilty. However, if you do not believe the defendant is guilty of an offense alleged in the indictment, or you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the accused defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts of this case objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment, and you are prohibited from discussing any potential sentences in this case. One of your first duties in the jury room will be to select one of your members to serve as the foreperson. He or she will preside over the deliberations, and he or she will sign the verdict, to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's point of view. Each of you must decide this case for yourself, but you should do so only after a full discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors. You are not permitted to conduct any research. You are not allowed to consult any other materials. And I don't believe that you'll have your phone, so I don't think that's an issue. So whatever your verdict is, ladies and gentlemen, it must be unanimous. The verdict must be in writing and signed by your foreperson, dated and returned to be published in open court. Now, ladies and gentlemen, we have prepared a verdict form that you'll be able to use. You will also have the indictment that fully sets forth all 12 counts. So as you go through the body of the indictment, you can read count 1, you can read through the entire language that is set forth in the indictment, and then you'll see that the verdict form says, we, the jury, in the above title action find the defendant, count 1, malice murder. And there's a block that you can check not guilty or guilty. And it's the same for all 12 counts. So after you have reached a unanimous verdict, and it has been signed and dated on the back page by your foreperson, you would then simply knock on the door, tell the bailiff that you have reached a verdict, although you would not disclose what that verdict is. Then we would bring you back into open court where your verdict will be published according to law. Now, there are going to be a lot of exhibits that will go out with you. These large boxes, the large boxes of physical evidence, we're not going to send those out with you at this time. But if you feel that you need to observe or look at those objects, if you would just simply write a note to the bailiff, and we'll be happy to bring you back out so you can take a look at the object that you wish to see. So I'm going to allow you to go back to the jury room at this time, but you will not begin your discussions and deliberations until you receive the indictment, the verdict form, and all of the physical evidence that will be sent with you. So you are excused at this time. All right, everyone, please be seated. Let the record reflect the jury's now out. Ms. Bayo, on behalf of the state, are there any objections to the charge of court?
There are no objections to the charge or to the verdict form, Your Honor.
Mr. Weinstein.
The defense also has no objections to the charge or the verdict form.
All right, thank you. So we've already reviewed all the exhibits. They're in proper order. I assume we can go ahead and have them sent out to the jury.
I don't dispute that, Judge. I know normally it's the court's practice to have 2 separate rooms for alternates to not be with the jury. I know we didn't put it on the record. I just want to make sure that that's very clear.
It is, and I've got their names. Let me get the
Mr. Weinstein.
Mr. Miller.
I just wanted to make sure.
Okay. The 4 alternate jurors.
Okay, guys. So we are officially in verdict watch. Whoever gets 45 minutes, wrong. They have been back there deliberating for 45 minutes and 32 seconds as we count. So there we have that. Okay, so what I would like to do in the in-between time, because I want to put up a poll for us, but I want to kind of give you an idea. So we got a kind of like, I don't want to say a cluster, but we do have a cluster, right? Okay. So we got a couple different trials coming up, right? Right now, currently, we have the Christopher Waffenberger trial. It has started. Today is opening statements, and I want to play kind of a it's a cold case. So I want to kind of give you a background on this one because we're trying to see which trials we should cover. Only because we know we got Donna Adelson coming up, right? And then we have another one with the Julio case coming up. So I want to let the chat kind of like decide which one we cover. So I want to give y'all kind of like snippets of what the cases are about. And then we can decide how we want to go from there. So I am going to share what they have on this first case. We already know we doing Donna. Donna's top notch, right? We gotta get grandma, right? So that's going to be the first thing. So I am going to share what they presented as far as the intro for this one on Court TV, and just to give y'all a preview, and then we can kind of decide which one we should go with. Here's the first one.
It's been a long wait, 25 years. But finally, hopefully, we will get justice for Melissa.
A Georgia man is now standing trial for the cold case murder of his wife, Melissa Wolfenbarger.
I've gathered the facts, and I collaborated with the DA's office and was able to get the facts together to come up with the probable cause to arrest Christopher Wolfenbarger.
We have finally made it. He's in custody. And now we just need to get over the last hurdle and get him convicted.
Christopher claimed back in 1998 that Melissa left on her own accord and never returned, but was arrested in August 2024, 25 years after Melissa's remains and severed head were found in trash bags.
I'm pretty sure it's domestic violence. He was captured in his home in Griffin. He hid. It took the detectives a little while to find him, and they found him, I believe, hiding behind a dryer.
Police also suspected Melissa's father, Carl Patton, a serial killer who committed 5 murders across Georgia from 1973 to 1977. News Nation's Ashley Banfield spoke with Melissa's mother about his reaction to the arrest of Christopher.
He was devastated when he found out she had been murdered, but he was deliriously happy as soon as he found out Chris had been arrested.
Christopher, who has pleaded not guilty, now faces life in prison for the murder of his wife, but her family says they knew since day one that he was responsible.
From day one, we knew it was Christopher. There was never, ever any doubt in our minds who did this.
Okay, so that's the first one. That one has opening statements right now going on. Y'all know I'm totally cool with leaving this room open, opening up another room for those that want to go look at opening statements, and we can replay testimony from this one in here, right? Now, this is the other one that's coming up. This one won't start until next week. I'm just trying to find a real good clip to give us like a that's a real. Okay, so just so y'all know, on this one that I'm gonna show y'all, it's a total of 5 people, 5 defendants. Everything was caught on video. The first person that's going on trial is Alicia Andrews, and she's the one that's that they have stated that she followed this rapper, well-known rapper in Florida, and gave the location and assisted the other guys who unalived him. So here's the news report for this one. And this one, the first girl, the first and only girl, it's only one girl involved. She stands trial next week. The other 4 defendants, which one of them is her, I think her baby daddy or her boyfriend, they are all facing DP. So their cases don't happen until like 2026 or so. Okay, so let's listen to this.
From Jacksonville and worked together to follow and ultimately kill a rapper who was here celebrating his birthday. 4 of those suspects appeared in court today. Fox 13's Ariel Placencia joins us live in Tampa. And Ariel, we know authorities are still searching for the 5th suspect, but you saw the 4 defendants in court today. What happened?
Well, Linda, today we learned that the state announced that it is considering the death penalty in this case, but a final decision has not been made yet on which of those defendants, if any, will be facing it.
All right, so all defendants are present, as well as their counsel and the state.
That's 4 defendants with 4 different attorneys, all appearing together in a Hillsborough County courtroom Wednesday. Rashad Murphy, Isaiah Chance, Sean Gathright, and Alicia Andrews are accused of making the trip down from Jacksonville to follow and track rapper Charles Jones as he moved around Tampa to celebrate his birthday in June. Eventually, the rapper, who also goes by the name Julio Fulio, went to the Home 2 Suites near USF, where surveillance video recorded 3 shooters firing at his vehicle in the parking lot, killing him, in what investigators have described as an ongoing gang war. In court Wednesday, the attorneys described a large amount of evidence that needs to be reviewed.
Inclusive of the in excess of 300-page police report, as well as what I anticipate to be dozens of listed witnesses.
Murphy, Chance, and Gathright all waived their right to speedy trial in court Wednesday. Here's Tampa criminal defense attorney Hunter Chamberlain, who is not affiliated with this case.
Normally, you would waive your right to a speedy trial because your defense attorney needs more time to prepare.
However, Andrew's attorney told the courtroom that her client, who is pregnant, would not be waiving speedy trial. This means the state must bring her to trial sooner rather than later. A preliminary trial date was set for this coming January.
And if you don't think the case against you is very strong, then what you are doing is essentially depriving the state of time to find witnesses, to find evidence.
Another potential strategy could be
that she will cooperate and provide information and even potentially testimony in exchange for consideration when it comes time to sentence her for whatever charges she has pled to.
Meanwhile, the state announced Wednesday that they are considering the death penalty.
Their final decision has not been made. It is going to be reviewed within the next 2 weeks, Judge.
Okay.
Now, the judge did set some preliminary dates today for those not facing the death penalty.
So the girl that y'all see in there, she did do a speedy trial, but I guess she, because she's pregnant, she decided not to do the speedy trial. So I'm assuming she didn't have the baby and everything since then. Yeah, I was wondering if she wouldn't do something like what Houston Danker did. Now that they have ruled that they just ruled yesterday that the defense cannot bring in this DV unless the door is open by the state. because she's trying to say that she was in an abusive relationship with one of the other alleged defendants, and with her, but the judge ruled yesterday that they could not bring DV in it. So I don't know if I don't know. I'm thinking that she probably, yeah, they did catch the fifth person. He just got caught not too long ago at Jason. So what I am going to do for all the people that's in the chat right now, I am going to send out a poll. Now that one doesn't start till next week, and we don't know if she's going to take a plea. She may pull a Houston Danker on us. But I do know that this other trial is currently going on. So I am going to put it in, and we'll kind of go from there. And remember, Donna Adelson tops it all, right? So however we go, we're going to make sure we definitely in the courtroom for every day of coverage of that one. And we'll kind of do these ones. I mean, Florida and Georgia, they running neck and neck in regards to the crimes. Right? Okay, so here we go. Let's start the poll now. Therapists, we are voting on which case we should cover. I just showed snippets of what each case is about, considering that we have the rapper one that is going to be starting next week. We currently have the cold case one that starts today. But most importantly, between all of this, we have Donna next week. We could cover both of them. My only concern with covering both of them is if we cover both of them and Donna comes up, we're going to be covering 3. You say you being selfish about your sleep? No, one is in, all of them are in Georgia and Florida, SD. Yeah, I know the Jews. And I'm fine with that. I don't want to put us, I know, nope, not 3, right? That's what I'm saying. I don't want to put us in a situation where we covering 3. Like if we can get one to jury before Donna starts, then I think that we can be good with doing both of them. And when I say both of them, okay. So what about this? What if we go ahead and start the Georgia today, since they are in open statements? I'm hoping that Alicia will take a plea deal because they have way too much evidence on her. And especially now that they ruled out the DV, maybe she'll take a plea deal. So maybe we should just work with what we have and what's currently in trial and where we currently have coverage. And let's start with our cold case in Georgia. How does that sound? Let me see what y'all voted. It looked like the cold case one anyway was close to winning anyways, the way the votes are going. Okay. Yeah, that's what I'm thinking. Okay, cool. Okay, let's do this. Okay, only because I don't want to do the cold case in this stream. Give me 2 seconds. Let me set up a stream for our cold case. And I'll leave this room open in case anybody wants to. I know people like to chat about stuff with the trial. So give me 1 second. I just got to set up the room. And then that way I can drop y'all the link and everybody can move over that wants to move over. And those that want to stay in here and chat, they can. I will replay testimony in this room while we wait for a verdict. Mm. I know this case is kind of ironic. Like her dad was the girl that was unalived in this one. Her dad was a convicted serial killer. Like they almost thought that he actually committed the unaliving of her. Right? That seems very, very ironic to me. Hmm. Hmm. Give me a second. I already had the thumbnail kind of together because I didn't know what we were gonna do, so I kind of did both of them. Ooh wee. Oh, okay. I'm like, now where did this go? What a mess. Mm. Here, I'll just put this. I'll put the thumbnail that I got right now in place, and I will redesign this a little later. I would like to add some more stuff to it. That's not me. Like, I want to add some more stuff to it, but just to kind of get us started over there. Okay, let me go over here and upload this. I gotta talk my way through it. Upload recent. Just so y'all know, the verdict clock is at 1 hour and 12 minutes. So it's still going down. Okay. Let me change the title to this. Okay, and let me go on here and get this for us. Okay, so I have the link for that one. I am going to put it in the chat in 1 second. Sorry, guys. Y'all know I do stuff on the fly. Let's see. Okay, cool. View. Let me get the link. There we go. Okay. Okay, so I will continue to, I'm gonna update the banner in this one. I am dropping the link for the Thanksgiving unaliving trial. We'll start the opening statements in an additional room. Once the verdict comes in, I will probably play the verdict in both of the rooms. In this current room where we are waiting on the verdict, I will replay some testimony. So I'll just play testimony in this current room right here. And anybody that wants to start with the opening statements, you're more than welcome to. If you want to catch up on any of the testimony in this one, cool. So here is this. That is the link. Make sure Shar gets over there. Shar, that's the link that you have to click to go. It'll teleport you. It's part of our musical chairs. Yeah, unless you want to stay in here, I'm gonna replay some testimony in here, Shar, but it's just up to you. We're gonna do opening statements in the cold case, one. Wait a minute. Yeah, there is a verdict. I tell you all that stuff I done went through.
All right, ladies and gentlemen, please be seated. All right, sir, are you the foreman of the jury? It's my understanding that the jury has reached a verdict.
Yes, sir. Yes, Your Honor.
Is it a unanimous verdict?
Yes, Your Honor.
Has it been reduced to writing?
Yes, Your Honor.
Have you signed and dated it as the foreman of the jury?
Yes, Your Honor.
If you would please hand the verdict form to the bailiff. I ask that the deputy clerk publish the verdict.
In the Superior Court of Liberty County, State of Georgia, case number 2024 R-67, State of Georgia versus Nicholas James Kassositis. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 4, concealing death of another, guilty. Count 5, possession of a knife during the commission of a felony, guilty. Count 6, possession of a tool for the commission of a crime, guilty. Count 7, possession of a tool for the commission of a crime, guilty. Count 8, possession of a tool for the commission of a crime, guilty. Count 9, possession of a tool for the commission of a crime, guilty. Count 10, possession of tools for the commission of a crime, guilty. Count 11, removal of the body parts from the scene of the death, guilty. Count 12, tampering with evidence, guilty. on this 14th day of August 2025.
Do the attorneys wish to see the verdict to make sure that it's in proper form?
No, Your Honor.
And are there any objections to the form of the verdict?
No, Your Honor.
Are there any other requests before we go into another hearing?
No request from the defense, Your Honor.
If I can just have one moment, Your Honor. Nothing concerning the jury, Your Honor.
And does either side wish to place anything on the record before I excuse the jury?
No, Your Honor, and I also don't seek to poll, just for the record.
Nothing from the defense, Your Honor.
Ladies and gentlemen of the jury, we've been here almost 2 weeks, and I wish to thank each and every one of you for your service. It is one of the highest forms of civic duty that any citizen can render to this state and this country, and we cannot resolve important cases like this without your willingness to serve. You've been diligent. You've been here every morning on time. You've been taking notes. You have done excellent work as a juror in this case, and it is sincerely appreciated, not only by me, but everybody involved in the criminal justice system. Your duty ends at this point, and I'm going to have to go into a sentencing hearing. There is one other thing that I do want to mention to you. I think you knew at the outset that this case was going to be televised, live streamed through various media outlets. And I want you to know that you have a right as a juror and as a private citizen. People may want to talk to you about this. Well, at this point, you can talk about it if you want to. That's totally within your discretion. It's my understanding that some of the media outlets may be outside. They may want to speak to you. That's solely up to you. I have no control over that. That's up to you. So when you see individuals who might be with the press or other outlets, that if you want to speak to them, that's fine. And if you don't want to speak to them, that's also fine. So there's nothing else I can tell you other than I sincerely appreciate your hard work in this case. I wish you well, and you are excused at this time. Thank you very much. Yes, ma'am. Everyone, please be seated. And I want to tell four of you, thank you very much for your service. The reason we select alternates is so All right, ladies and gentlemen, we'll be in recess for about 10 minutes, and then we will begin the sentencing hearing.
Thank you, Your Honor.
Okay, so they are going into sentencing for our guy Nick Stark, Jim McIntyre, whatever. Iron Man, He-Man. He can't believe it. Oh, look at the parents. They crying. Oh, they so upset. They boy that he is so deranged and strange is going to jail for the. Oh, he crying, y'all. They're like, you can't be doing this. Get off your parents. Doug said, come on, man. Come on. They don't have no sound in the courtroom, just so y'all know. Yeah, he's in custody. He couldn't make bail. So those that are in the room for our Thanksgiving unaliving trial, just so you know, we will get started with that. We will continue to look at the sentencing in both rooms. And then once we're finished, we will get to the Thanksgiving unaliving trial. So we'll just, hang out. He allowed it. SD allowed the hug. He just said, y'all not gonna be sitting up here hugging too long. Like, what you thought this was? You not free? Yeah, because he couldn't make bail. He had bail. He just couldn't make it. Oh, the daddy is too through. I said, now, as soon as I did all that work to get this other room set up and drop the link, and no sooner than I dropped the link and people started moving, I was like, I heard sound in my ear, and I'm like, verdict. Oh gosh, now I got to change everybody around. But instead of changing everybody around, I'll just keep both rooms open, and then that way we'll just watch it in both. Because I was like, by the time I tell them to go back to the other room, like, okay, we can play musical chairs, but I don't want to drive y'all crazy. Yeah, the dad is like, he is distraught. Hey, Irish, how are you? Yeah, he let them hug for a minute, but he came over there and was like, no. Hopefully Doug got him together, because Doug looked like he interjected. Like, come on. Let him hug him. So sad. It's sad for all people involved with these cases. It's like nobody wins. Of course, they got justice for Mendy in some shape, form, or fashion, and he did not get away with this. But it doesn't change the circumstances, and unfortunately, his family. I mean, they went back to the jury room, picked the foreperson, and was like, okay, Let's vote, everybody. What do y'all think? Everybody raise their hand at the same time, talking about guilty, 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 guilty on all 12 counts. Once they got finished with guilty on all 12 counts, they signed it and they sent it in. Like, that's all they could have did back there. There was no argument. There was no nothing from anybody. Yeah, Shar, way more. Right? I mean, like, even, down to the third wife. Like, oh my gosh. Like, she even tried, and he still scammed her in some shape, form, and fashion of who he was and what he represented. Don't worry, guys. People that's over here in regards to the cold case, Georgia unaliving trial, just to give you an update, we're just finishing up. The verdict came in for our guy, Nick Kassositis, Nick Stark, Iron Man, Tin Man, Rain Man, who knows man, trial. So we're just going through the sentencing phase. Once we are finished with the sentencing phase, we will go directly into opening statements. So you won't miss not one moment in regards to the cold case, Thanksgiving unaliving.
Council ready to proceed?
Yes, sir.
Okay. Everyone please be seated. All right, in case number 2024 R67, the jury having reached a verdict of guilty as to all 12 counts in the indictment, is the state ready to proceed with sentencing?
The state is ready to proceed with sentencing, Your Honor.
Is the defense ready to proceed?
The defense is ready to proceed, Your Honor.
Does the state have evidence in aggravation?
Yes, Your Honor. The state intends to call two witnesses and one statement that I will ask Ms. Ashdown, our victim witness advocate, to read. So the state would call would the court like me to proceed?
Yes, ma'am.
At this time, the state would call Megan Mevin to the stand. Ms. Mevin will be speaking on behalf of the family of Mindy Mevin, Your Honor. Do you wish her to be there?
She might be more comfortable just sitting up there. Please raise your right hand before you're seated.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I just ran up the stairs, so sorry if I'm.
Just hold on. Just catch your breath.
Okay, let's see. All right. I've kept up with the entire trial and decided to drive 3 hours this morning to be here because I couldn't let this chapter of my life end without at least saying something. Unlike you, I have cried a lot over the last few weeks. My thoughts, anxiety, and emotions have been a roller coaster. They have been all over the place while having to deal with this trial. I go through anger, sadness, frustration, grief, stress, and every feeling that you can think of. You lived with us for 15 months with providing no financial contributions. 15 months that I will never be able to get back. At times when you lived with us, I told you how your actions had affected me, and this impact statement isn't much different. Whether you take away anything from this, that is not my intention at this point. You've shown no guilt and absolutely no remorse. You haven't even shed a tear. You thrive on the illusion of power and attention. You're a pathological liar, sociopath, psychopath, murderer. You thought you were so much smarter than everyone else, but you aren't. You wanted people to believe you were a victim of abuse, while you were the one being abusive, at least mentally. You have forever changed the meaning of trust for me and our family. I can no longer trust people in the same way as I did before you continuously lied and ultimately took Mindy's life. There will always be some questions that will go unanswered, but to answer them would mean to try to understand a murderer's mindset, and that is one I will never understand. Mindy was bright, beautiful, empathetic, confident, independent. She loved music and making others feel special. She always put her family and friends first. Once my husband Frank and I had our daughter, Mindy wanted to choose a name that was different than the traditional aunt name. She decided on Lulu. She was never able to hear her sweet niece call her that. My daughter was 5 months old when y'all moved in. She will never know the fun times they experienced together. I'm thankful my daughter does not remember the 15 months you lived with us and sat right next to her at the dinner table. My daughter will never be able to experience the love her Aunt Mindy would have continued to give her. Mindy was taken too soon. No one should have to live through the violent and gruesome murder of a family member. You're a very evil man. When I learned the news of what really happened to Minnie, some of my first thoughts were that I couldn't believe that evil man lived in my house in a bedroom next to my 5-month-old daughter. You have no remorse for what you did. This loss has impacted so many beyond our family. The emotional wound you have caused will never heal. We have comfort knowing she is in heaven now, free from the trials and scars of this earth. We have overcome hatred, darkness, and evil. She is looking down on us now, being proud of how we have overcome. We are done being victims. We are taking back our lives. Since I'm a science person, I'm going to quote Isaac Newton. Every action has an equal and opposite reaction. Our family believes you deserve the maximum sentence, life without the possibility of parole, because Mindy doesn't have a parole. You deserve to sit in prison for the rest of your life and think about Mindy every single day. Thank you, Your Honor.
Thank you.
Your Honor, this time the state would call Morgan Paddock.
You can raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
There are people literally all over this world that have been impacted by Mindy's life, and I'm here to speak on behalf of them. I always say my worlds collided with Mindy. Not only was she my high school friend, but after moving to Savannah, all of my college friends became her friends too. My roommates became her roommates. My church group became her church group. This entire trial has rightly been focused on what happened to Mindy, but Mindy was so much more than what happened to her. She was a bright light, vibrant, generous, funny, caring, a defender of others, passionate, trustworthy, and so much more. If anyone in her life would have been in her position, she would be standing right here today speaking for them. Nick, you slowly and strategically tried to dampen her light, isolating her from the people she deeply loved, robbing her of time, laughter, creating memories and peace, always living in fear and isolation. She loved you and trusted you to tell her the truth, to protect her, to live out your marriage vows. And yet you were the one that she needed protection from. Her death has had and will have an eternal impact on those that loved her. There are dinner tables and holiday pictures and memories that will be absent of her. There are little girls growing up without their fairy godmother. There are friends who will always ache to dress up and go out for drinks again. Email inboxes void of her opinions on the latest happenings in politics. Friends who can't expect her to stand with them in their proudest and hardest moments. Friends who won't have her in the audience of their concerts or harassing them for their latest released music. My everyday life in Savannah is now filled with the awareness that my friend was living and suffering within walking distance of my house. And I never knew. I will never be able to drive down 65th Street, go to a Smoothie King, pick up meds at CVS, or buy tennis shoes at our local shoe store without being haunted by the fact that you were frequenting all of those places for 5 months while my friend of over 20 years was suffering in fear and isolation as I drove mere feet from her driveway. But it's not just me and her friends that will miss out. This entire world is impacted by the ending of her life too soon. There are compelling women whose stories she will never get to tell on her podcast. There are strangers who will never know the beauty of the sound of her laughter or the impact of her most fiercest eye roll. Your conviction can't bring her back. It just means that you can't do it to anyone else. But every person you heard from on the stand and the many who are watching right now from a distance will never stop keeping the truth of who she was and her memory alive. You may have taken her life, but you will never be able to take her legacy, and she would want you to know that today.
Your Honor, the state has one final statement that I'm going to ask to be read into the record. That statement would be read by Ms. Samantha Ashdown, our victim witness advocate, on behalf of Samantha Koyesnik.
All right. And the defense will object to the reading of that statement, as Ms. Koyesnik, while obviously a victim of the circumstances here, is not a victim under the law that would be entitled to read the statement to the court.
But Judge, my position on that, as the court is aware, is that this is evidence in aggravation, not a victim impact statement.
It is. I'll overrule the objection. Thank you, sir.
Thank you, Your Honor.
Yes. There's no need to swear.
To the court and to the Honorable Judge Rose, my name is Samantha Kolesnik, and I am a victim of the defendant, Nick Kassositis, aka Nicholas Stark, the latter of which is the name he used while victimizing me in Pennsylvania. You were able to hear my testimony against Nicholas during this trial, and you were able to hear and see my pain and my tears firsthand. I recounted his horrible acts of deception against me. I trembled taking the stand to testify. It was the hardest thing I've ever had to do, but I did it because I feel Nicholas is a true and constant danger to everyone he meets. I feel that if given the chance, Nicholas will continue to exploit, abuse, deceive, and harm others. I testified knowing I would be filmed against my consent and that I would be humiliated in admitting I was defrauded by a man I met online, and that my privacy would be forever gone. I testified anyway because I strongly feel and believe that Nicholas is a danger to society and that he must be held accountable. Ms. Bayo, ADA for the prosecution, mentioned ripples from Nicholas's dropping stone as an analogy for an impact of his choices. I am one ripple. I have not been the same since I found out about his deception from Agent Sands, and I will never be the same again. On the date of his arrest, when Agent Sands of the GBI told me Nicholas Stark was not his real name and that Nicholas had been lying to me, my entire world turned upside down. My sense of trust shattered. I felt humiliated, deceived, traumatized, and unsure if I would ever be able to feel joy or hope or trust again. I also felt stupid and will continuously be called stupid and gullible by some in the public eye as a result of trusting a man who was once a naval officer, a JAG, an employee of the Pentagon, a man who had every opportunity and privilege in life. Everyone trusted Nicholas, and he knew it. and he privately relished and delighted in lying to them and in abusing that trust. He is a man who delights in deception, a man who thinks he's smarter than everyone in the room he walks in. I also felt terrified beginning on the date of his arrest and thereafter, and will forever be haunted by what he would have potentially happened to me if the GBI and Detective Jack Frost's team had not tracked, found, and arrested Nicholas Stark, aka Kassositis, when they did. I fully believe that the wonderful law enforcement agencies of Georgia saved my life that day, and I will be forever grateful to them for saving me from the evil man who goes by many names, one of them being Nicholas Stark. I was diagnosed with PTSD, post-traumatic stress disorder, as a result of Nicholas Stark's cruel actions towards me. I have nightmares, flashbacks, and panic attacks. I lock my bedroom door every night. I do not feel deceived by Nicholas Stark, aka Kassositis. I feel raped by him. I was not allowed to consent to a romantic and intimate relationship with Nicholas because he lied about his entire identity to me. There was no opportunity for true consent, and he ensured that with his vast network of lies. This is called rape by fraud, but unfortunately is not recognized in Pennsylvania, so all I could do was pursue an annulment on the basis of his fraud. I am sure Nicholas Stark, since he is a lawyer after all, knew those statutory limitations when he deceived me. I do not feel Nicholas feels 1 ounce of shame or remorse for his deceptions against many people, including those he perpetrated against me. He has sat in this courtroom and has attempted to make every mockery of it with his smug expressions, his arrogant demeanor, and his lack of tears as his victims, one after the other, have talked about how he deceived them. I beg and implore and plead to the court, please give this man the maximum sentencing. And please, if at all possible, by sentencing protocol and legislation, please do not allow this man to do paid interviews or in any way profit from his crimes. Nicholas, due to his sick need for control and his sadistic desire to humiliate and defraud others, will absolutely try to profit off his crimes in prison. Please do not allow Nicholas to write books or to sign movie deals or even take paid interviews. He must not be allowed to extract any more from the victims than he already has taken so much. I also ask that he not be granted any chance for parole. A man who lies as much as Nicholas has and will always be a danger to society, especially the most trusting and vulnerable among us. Sincerely, Samantha Kolyasnik.
Thank you.
Those are the only evidence of aggravation that the state intends to present. Do you wish the state's argument, or do you wish to have mitigation
I'll wait till I hear
first?
from the defense.
Certainly not.
Does the defense have any evidence in mitigation?
Just like to present the defendant's mother to testify in mitigation.
You may.
Father, I'm sorry, father. One at a time. So, 2 witnesses, Your Honor. Defense calls Wayne Kassositis.
You can come up here, sir.
I'm excited for you here, Your Honor.
That's fine.
Thank you.
Can we swear you in, sir?
Oh, absolutely.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Absolutely. Good morning, Your Honor.
Yes, sir.
Heard a lot of things in this courtroom this morning. Last over 2 years have been hell for all of us, including Nicholas. Although I don't agree with the verdict that was reached in this court, that the jury reached, I do respect the process. They have no idea who Nicholas was. Nicholas is a kind, gentle man that has touched thousands of lives, both as a civilian and as a military person. Nobody saw pictures of him helping underprivileged children in South America as a naval officer. Nobody saw him helping friends as he was growing up He is truly a wonderful, kind person. And from the beginning, when this all broke, from the lies that Agent Sand told to family members, we never believed that this was possible, and we still do not believe that this is possible. We know the person sitting there, our son, as a kind and gentle person that would not do this. And there's really no evidence that showed that he did. I just want you to be considerate and look at the man who he is and who always will be. Thank you, Your Honor.
Thank you, Mr. Kassositis. Thank you very much.
The defense calls the defendant's mother, Linda Kassositis.
Ma'am, you're welcome to stand here or you can go up there.
Stand here.
If you would please raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Your Honor, I would like to say first how incredibly sorry we are for Mindy's family that they had to go through this. We have never spoken since we heard the news of Mindy's death, but we feel incredible sympathy for them that they lost their daughter. But Nicholas was not responsible for this. We know him to be a kind and gentle person. As you know from the testimony, we had not been in touch with him for years through circumstances beyond our control, and every member of our family suffered as a result of that. People missed him so desperately. My mother said she had never gone a Christmas without seeing or hearing from him, and suddenly he was gone from our lives and we had no idea why. He is a good and kind and gentle person. The thought that he could take someone else's life is just unbelievable, honestly. I respect the jury's work that they did, but they got this one wrong. I'm sorry. Thank you.
Thank you. Anything else, Mr. Johnson?
No, Your Honor.
All right, this time I'll hear argument from counsel.
Your Honor, may I?
You may.
Your Honor, this case is a case that the court has obviously spent the last 2 weeks present for and listening to all of the testimony. As a result, I don't plan to go over any of that. I think Morgan may have said it best when she described how Mindy and her life impacts the world. When a sentence is rendered, I think the court has always, and I think I've even heard you say, has to evaluate not just how it impacts the defendant, but the message of rehabilitation, if possible, versus punishment, if necessary. The law in the state of Georgia entitles on a murder conviction only 3 options, essentially: the death penalty, life without parole, or life with the possibility of parole. In this case, Your Honor, the defendant is additionally facing all of the additional crimes that can run consecutively. That would be the concealing death of another, which he faces up to 10 years, possession of a knife during commission of a felony, which is mandatory 5 years consecutive, although it could be, of course, probated. And then all of the counts of possession of tools for the commission of the crime that he's facing up to 5 years for each of those. And then the 2 misdemeanors are, of course, up to 12 months. That is more than what I would refer to as natural life. The state's position, Your Honor, is that the defendant should never be released from prison, that he is a danger to society, that his testimony before this court under oath was fraud, that he was dishonest, that he perjured himself. And that, of course, is the state's position. I'm sure counsel for the defense would disagree. And
I think that goes to the question, however, of whether or not there is remorse or whether there is some validation to something less than life without parole. The jury has now determined that he not only killed his wife, but that he threw her out like garbage across 3 miles with the hope that no one would ever catch him. If that depravity could not be any worse conduct to deserve life without the possibility of parole, I don't know what could. But for the good work of members of law enforcement, all of the teams that worked so hard to run every detail down, we would not be here today. And so, Your Honor, it is the state's position that the defendant in this case should get the maximum sentence of life without the possibility of parole. The state will defer to the court with respect to all of the other counts, as I essentially believe that they are, you can't get more than forever. Thank you.
Thank you, Ms. Taylor.
Your Honor, the jury has rendered its verdict. While obviously we don't agree with that, we understand that is your obligation to sentence him under that verdict. Mr. Kassositis is a highly educated man. He's a man that served his country honorably. You've heard a lot of testimony, not just from his parents, but from witnesses on the stand, of his kindness. I think there is an opportunity for rehabilitation in this case, especially given his past. So I would ask the court to sentence him to life with the possibility of parole. Those other counts that can be served concurrently, that the sentence have them served concurrently. I understand there's one count that must be consecutive. So that's the position of the defense, Your Honor.
Mr. Weinstein, your client has the right to address the court if he so chooses.
Let me verify. He will not be addressing the court, Your Honor.
Then have him stand for sentencing. Mr. Kassositis, a jury of 12 citizens in Liberty County, Georgia, has now determined beyond a reasonable doubt that you are guilty of the offense of murder, along with 11 other counts. This jury has spoken very clearly. It is now my duty under the law to impose a sentence that is consistent with that verdict. It is also my duty to look at the evidence and weigh the sufficiency of that evidence. And sir, the evidence in this case is supported by a mountain of compelling evidence. This case has revealed a level of depravity that truly shocks the conscience. To put together this elaborate scheme, this web of lies, creating this fictional character, Jim McIntyre, who does not exist. You wrote fiction, and your life was a fiction, at least the last 6 or 7 years. And then you carried out, or the evidence shows that you carried out, a brutal, horrific, gruesome murder of Mindy, someone who's been described by various witnesses as beautiful, kind, loving, vibrant, smart. And all of her hopes and dreams vanished in an instant. Her life tragically cut short by you. Someone who professed to love her, to care for her. Just the ultimate betrayal. And then you desecrated her body in such a vile way, discarding her remains out in a rural area of Liberty County, hoping that they would never be discovered. This shows beyond all doubt that you have no conscience. When I described to this jury this morning the elements of the crime of malice murder, the language used in the Georgia statute is that the circumstances show an abandoned and malignant heart. That describes you. You have caused so much harm to your own family, to all of those who have been impacted by your deeds. This is truly a heinous crime. So the court has considered all the facts and circumstances of the case. And the court will now impose sentence that reflects the gruesome nature of your criminal conduct. As to count one, malice murder, the court hereby imposes a sentence of life without the possibility of parole. Although you've been convicted in count two of felony murder, that count would merge into count one. As to count three, the sentence of the court for aggravated assault is 20 years to serve in the state penitentiary, and it runs consecutive to count one. Count four, concealing the death of another, the sentence of the court is 10 years to run concurrently to count one. Count five, possession of a knife during the commission of a felony, it's required to be consecutive. So the court imposes a sentence of 5 years consecutive to count one. As to count six, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to serve, and that shall run concurrently to the other counts. Court will impose the same sentence on count seven, 5 years to serve, running concurrently. As to count eight, possession of tools for the commission of a crime, again, the court will impose a sentence of 5 years to run concurrently. As to count nine, possession of tools for the commission of a crime, the court imposes a sentence of 5 years, again to serve concurrently. As to count 10, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to be served concurrently. Counts 11 and 12 are both misdemeanors. They carry a maximum sentence of 12 months. The court will impose a sentence of 12 months as to each count, counts 11 and 12, and they shall run concurrently. The totality of the sentence being a sentence of life without parole plus 20 years to serve. Sir, you have a right to seek post-judgment relief from your convictions of these crimes. And you can do that by filing a motion for new trial or filing a direct appeal to the appellate court. That will have to be filed within 30 days of today's date with the clerk of Superior Court in Liberty County, Georgia. If a motion for new trial is made and the court denies it, you will then have 30 days from the filing of that order to file with the clerk a notice of appeal to the appellate level. You also have a right to file a petition for habeas corpus. And that would have to be filed within 4 years of the date that the sentence and judgment in this case is deemed to be final. If you cannot afford an attorney to pursue your appellate relief, a lawyer will be appointed for you, and I'm sure that Mr. Weinstein will discuss with you all of your appellate rights. Is there anything else that needs to be placed on the record before the defendant is remanded to custody?
Your Honor, I just want to clarify, the court indicated life without parole for count 1, 20 years to serve consecutive on count 3, and 5 years to serve consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the record was
I
correct.
misspoke.
Thank you, sir.
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's the only position on the state.
He is remanded to custody. Court stands adjourned.
Thank you, Your Honor.
OMG. Why didn't we get the handcuff, the clink clink? We supposed to be able to see it all. Them parents is very delusional of his. That mama, really? Oh boy, I know you gotta love your babies, but golly, you talk about a whole mess. I guess they still sitting and waiting. Here, guys, I am dropping the other link for the other room. Yeah. So I'm dropping the link to everybody in the actual verdict. I don't know. I'll keep it open to see if there's a press conference on OnlyFans. I'm not sure. In regards to the Thanksgiving unalive trial, we are going to get ready to get started with opening statements very shortly. Just so y'all are aware, we have a new trial that's starting today. They're still showing family things, so I'll keep it together. Yeah, the Jules, I agree. That's how I don't know how she got up and was able to make that statement.
They also learned that from that neighbor that Christopher works at Action Glass down on Avon Avenue. So they drove down to Avon Avenue and talked to the people.
Okay, guys, hey, Melanie, welcome, welcome, welcome. Thank you, thank you, thank you. If you don't know, we're starting a new trial today. I'm putting the link in. We're going to go over to this room and start covering it. Very, very sad. I totally agree. Wait a minute. I got to figure out which room I'm in. No, I'm in the right room. Oh, gosh. Sorry, Melanie. You in the right room. Oh, boy. Okay, let me shut down one of these rooms before I be totally confused and confuse everybody. Hey, Tracy. Here you go, guys. This is the link for the Thanksgiving unalivened trial. You see it just kind of like popped up on the screen. We are going to move over to that trial and start covering it. Today is opening statements. So we're going to jump on in. Of course, we'll have some TiVo time. So when they take lunch, we'll probably be catching up on our testimony there. Thank you guys for coming over and watching the verdict watch over here. And I'll see you over in our Thanksgiving unaliving trial. All right, guys, click the link.